Greetings, campers, and welcome to the second in our series of TELUS webinars. I'm Scott Walker. I am the Executive Director of CSARN. It is a pleasure, as always, to welcome artists from across the country today. And I would like to begin by acknowledging that we live, work, meet, and travel on the traditional territories of Indigenous peoples that have cared for this land, now called Canada, since time immemorial. We would also like to acknowledge this as part of our covenant with all Indigenous nations to share, respect, and protect the land in the spirit of peace and friendship, and to honor the future generations of all of our nations. All right, copyright, a complex topic, or actually probably a bunch of topics. How do you need to know how to protect your work? How do you need to know what you need to know in order to protect your work? Well, hopefully we're going to get some answers to some of those questions today. I'll just tell you how things are going to unfold. We will hear a presentation from our expert, and then we will try to answer as many of your questions as possible. Actually, he'll be doing most of the answering because I'm here to learn as same way as you are. You have two ways of communicating with us. One is the chat box, and the other is the Q&A box. If you have questions, we ask you to put them in the Q&A box. It makes it easier on our end. And we'll try to get to as many of your questions as possible. All right, time to introduce today's presenter. He is counsel at Denton's. His specialty is the interface between the arts and the intellectual property law. Please welcome Bob Tarantino.
Excellent. Thanks, Scott. I appreciate all of you joining us today. I'm going to start sharing my screen. Hopefully this will work. And I am confident, relatively, that you're able to see my first slide. I am going to be moving at a relatively brisk clip through these 6 topics, but feel free to pose questions as we go along. I'm going to start just sort of centering us and giving us a basic, very broad strokes understanding of what copyright law does. Then we're going to talk about moral rights, which are of particular relevance to artists and creators. We'll talk about registration, reversion, which is a very tricky topic, but something that is of particular interest, I find, to many creators. Then we'll touch briefly on some options for enforcing your rights in the event that you find them being infringed. And finally, we'll move on to the perennial mystery of fair dealing and spend some time going through some actual examples of cases where the courts have applied fair dealing, and we'll see how they think about it and how you can think about it. So, copyright law basics. The challenge and the benefit of copyright is that copyright covers a lot. It lasts for a really long time, and it's complicated. So when I say it covers a lot, what I mean by that is that pretty much everything that you create as an artist is going to be protected by copyright from the moment that you create it. Everything from emails to novels, everything from doodles on your notepad to giant murals on a wall drawn with spray paint, every song, every iPhone selfie, every feature-length film that you film is protected by copyright. The term of copyright protection in Canada, and I just want to flag one thing here because this is a little bit of a complication. Today, at the moment, the duration of copyright protection in Canada is life of the author, the sort of default general term of protection is life of the author plus 50 years. That will change before the end of this year. So sometime between today and December 31st, 2022, that term is going to be extended by an additional 20 years. So it's going to last for the life of the author plus 70 years. That will align Canada's copyright term with the terms found in the United States and the EU and most of the other countries around the world. You start measuring the duration of copyright at the end of the calendar year in which an author dies, and then you add 70. And then on the 70th anniversary of the author's death, on December 31st of that year, copyright expires, it ends, it terminates, and on January 1st, it's what they have created is in the public domain. So every year on January 1st, we get a new batch or collection of materials that are released into the public domain. When we say that copyright is complicated, and we're going to see some illustrations of that over the next 45 or so minutes, part of the reason for that is that while there are basic broad similarities in every country around the world, each country has their own kind of bespoke approach to copyright. And so copyright operates in different ways in different countries. So it's very difficult to make a sort of universal or worldwide declaration about copyright law. And so for today's purposes, I'm going to be talking almost entirely about copyright in Canada. We'll sort of take some glances at how it works in the United States for comparative purposes. But you have to keep in mind that copyright operates all over the world and operates differently in every country. Copyright is also quite complex in the sense that a single thing, a single piece of creative expression can be subject to multiple different copyrights. So for any of you who are songwriters or musicians, you will probably know that a song, what we refer to as a song colloquially, is actually made up of at least two or three different copyrights. There is the copyright in the musical composition, the sort of arrangement and sequencing of the notes. There is copyright in the sound recording of that composition, and there may be copyright in the performances of the musicians and vocalists who perform on that sound recording. So it can be very difficult to analyze copyright because a lot of times it's quite dense. Another challenge is that copyright can be owned in different ways by different people in different countries at the same time. So for example, films, they can be licensed or distributed around the world to different distributors or different licensees in different countries. And so it can sometimes be a challenge to identify who the actual owner of a particular right in a particular territory is. The other challenge, and probably the most vexing one in the contemporary world, is the internet and digitization. And as I'm sure many of you know, the availability of content on the internet means that infringement happens almost instantaneously and almost continually and almost everywhere around the world. And so that can be a real challenge for those who own rights and try to manage those rights. And we'll talk briefly later on a little bit about how you can think about approaching the enforcement of your rights in that environment. Just to ground us in for the purposes of the rest of the discussion, copyright in Canada arises under the Copyright Act, which is a single piece of federal legislation which applies across the country. It protects original and fixed works of expression. The Copyright Act also grants authors what are referred to as moral rights, and we'll talk more about those in a moment. And copyright also protects what are sometimes referred to as neighboring rights, which are performances. So primarily musicians' performances, but also actors' performances and vocalists, sound recordings, and broadcast communication signals. So I'm going to move on to talk about moral rights. Moral rights are a sort of source of perpetual concern. To understand moral rights, we're just going to talk very briefly about a Supreme Court of Canada decision identified up there at the top of the slide. It's the Théberge decision from 2002. And what the Supreme Court told us was that our Copyright Act really contains two different sort of visions of copyright. One is an economic right. So that is the right to reproduce a work. It's the right to communicate a work. It's the right essentially to monetize a work, right? To inject something that you've created into the stream of commerce. The second conception that's embodied in the Act is what are referred to as moral rights. And as the court described them, these moral rights adopt this more elevated and less dollars and cents view of the relationship between an artist and his or her work. Right? They treat the work as an extension of an artist's personality, right? And the view is that artists, by virtue of having created something, have done something which is worthy of protection, entirely irrespective of the exploitation value of what has been created. So moral rights belong to an author and to the author's heirs. So that's absolutely critical. The only people who have moral rights are authors. So companies, corporations, artificial legal entities can never have moral rights. It's only individual human beings who create something that have moral rights. And those moral rights last for as long as the copyright lasts. Right. So as I said before, they're going to last for the life of the author plus 70 years. Moral rights can be waived, but they can never be assigned. Right. So moral rights start with the author and they always stay with the author. You can't transfer your moral rights to another author. You can't transfer your moral rights to a publisher. You can't transfer your moral rights to a movie studio. Moral rights start with you as the creator. They stay with you forever. It's critical to understand that because ownership of the thing you create, ownership of your work can be moved around, right? So if you write a novel or if you write a textbook, you can transfer the copyright in that textbook to your publisher, but your moral rights will never move with the title to the copyright. The only thing that authors can do is waive their moral rights. So just before we drill down on what it means to waive your moral rights, let's identify what the three moral rights are. Those rights are the right to attribution. So that's the right to be identified as the author using the name that you prefer, whether that's your own name, a pseudonym, or remaining anonymous. It's a right of integrity. So it's the right to object or control against the distortion, mutilation, or modification of your work in a way that prejudices your honor or reputation. And it's the right to control the association of your work when it's used in association with a product, service, cause, or institution in a way that you feel prejudices your honor or reputation. Those all sound great if you're a creator. The challenge is, in most industries, you will be asked to waive your moral rights as a matter of course, right? So most publishing contracts, certainly every contract I've ever seen in the film and television space, most music contracts will require authors to waive their moral rights. As a practical contractual matter, you almost certainly have to waive your moral rights in order to get that contract signed. But there is a set of solutions that I want to draw to your attention. So if somebody asks you as an author to waive your moral rights, what you should realize is you can waive them, but also protect them by means of the contract itself. Right? So you say, on the one hand, fine, I'm waiving my moral rights. However, in exchange for me agreeing to waive my moral rights, I need you to give me certain contractual protections, such as specifying what changes can be made with or without your approval. Right? So if you write a novel, they can't change the ending, they can't add chapters, they can't subtract chapters, they can't remove characters, they can't add or remove plot lines, etc. Specifying contractually which uses trigger approvals. So for example, it's very customary in the music space to have author composers waive their moral rights in their songs, but then limit the ability of their publisher to exploit their songs in connection with certain types of products or services, right? Such as tobacco, alcohol, guns, hygiene products, and then other things that may be more specific to an individual author. So some composers will say they don't want their music used in connection with oil and gas extraction industries, cars, different types of, NFTs, cryptocurrency, different types of concerns are raised by different people, but all of which can be dealt with in the contract itself. If you're going to impose those kinds of approval rights, you should make sure that there's a specified and explicit way of obtaining those approvals, right? So if somebody needs your approval to do something, set out how it is that they have to contact you in writing, specify how many days you have to deliver a response, specify what happens if you object or if you approve. And then finally, and I think this is a useful tip for contracting, regardless of whether moral rights are addressed or not. Always include an explicit credit provision in the contract, right? Always specify how it is that you as the creator need to be identified as the creator of the work in question. Whether that's, if you're the author of a book on the cover, if you are the director of a film, in the opening credits, in the liner notes of a music release, etc. Those items there that I've identified on screen, I think will help you overcome and sort of work around this concern about waiving your moral rights, which you will almost inevitably be asked to do. Let's talk for a moment about registration. So Canada has a copyright registry. It's maintained by CIPO, the Canadian Intellectual Property Office. You do not need to register your copyright in Canada. It's a good idea to do so, and we'll go through what the advantages are. But bear in mind, you don't need to register your copyright in Canada. Under Canadian law, copyright accrues from the moment of creation. So as soon as you have created your work and you've satisfied the various thresholds, such as originality and fixation that are set out in the Act and in the case law, you enjoy the benefit of copyright. The United States is a little bit different in this regard. So it used to be that in the United States, you had to register in order to have copyright protection at all. That was changed, I believe, in the 1980s. I could be wrong about the exact date. In any event, at the moment, you do not technically need to register your copyright in the United States. But practically speaking, in the United States, it's a really, really, really good idea, because if you don't register your copyright in the United States, you can't commence a lawsuit in the US federal courts or obtain statutory damages. So just keep in mind that there's a distinction between how Canada and the US treat registration. Bottom line, Canada, you don't need to register your copyright. If you do decide to register your copyright, you can do it online, or you can mail in an application. You print off the form off the internet, fill it out, mail it in. If you do it online, it's cheaper. I believe it's $50. If you do it online, and it's, I think, $85 if you decide to send in the paper copy. The forms are relatively simple to fill out, and the Canadian Intellectual Property Office does not substantively review the form. So what I mean by that is they don't check to see whether you've actually created the thing that you've said you've created. They don't check to see whether the title matches up. All that they do is check out whether the form has been filled out correctly and whether you've paid your fee. It's a fairly simple form to fill out. You fill out your name, you fill out your address, you fill out the title of the work, what kind of work it is, whether it's a literary work, musical work, etc. You identify the author, the owner, and the place of first publication, and that's it. Then you get a certificate in the mail about 4 to 6 weeks later. Also, keep in mind that in Canada, you do not need to send in a copy of the thing you are registering. In the United States, you do need to send in a copy of the work that you are registering. And that can get a little tricky because US law requires that you send in what's referred to as the best edition of the work. And that is a sort of technical sinkhole which you can get into. In Canada, you don't have to worry about any of that. You don't have to send in a copy of what it is that you are registering. Somebody has asked for how statutory damages work in the US. I will talk about that later when we talk about statutory damages in Canada. But if I don't remember to address US statutory damages, please remind me. Why should you register in Canada? Well, it's relatively cheap, depending on how many works you need to register. It's $50 for the online application. It's also really helpful if you are ever going to enforce your rights. So having the registration, you get your certificate, that is presumptive evidence that you own the thing that you say you own, and that the thing that you say is registered actually exists. That can be really valuable, because if somebody that I know, if one of my clients gets sued for copyright infringement, the first thing I always say to them is, okay, well, we're going to challenge the plaintiff to prove that this thing exists, and we're going to challenge them to prove that they own it. If they have a certificate of registration, they don't have to worry about any of that stuff. It's also helpful because what it does is it prevents somebody from claiming that they were what is referred to as an innocent infringer. So an innocent infringer is somebody who essentially says, I had no idea this thing was protected by copyright. And because I had no idea, I'm not liable for any monetary damages. The only remedy that you can obtain against an innocent infringer is an injunction. If you register the copyright, nobody can assert the defense of being an innocent infringer. And then just as a reference point, and as I'm sure some of those listening to this know, for some transactions, like if you're getting a loan from a bank, which is secured by copyright, you need to register the copyright in order to obtain that loan. I'm just going to refer to some of these questions. You're talking mainly about writers and musicians. Does all of this refer to artworks by visual artists too? Absolutely. Everything that I have said so far applies equally to all different types of art in all different media. For the USA, how about if the work is in French? Do we have to register the rights anyway, or just for the English version? So I think the question is, if there are multiple versions of a work in different languages, do you have to register it in all of the relevant languages or just one? It's a good idea to register it in all of its relevant languages. Each different language version has a separate copyright. So you can register the English version, you can register the French version, you can register the German version. All of those different versions are their own separate copyright, and you should feel free to register all of them separately. Going to move on to talk about reversionary rights. This is a bit of a mystery for many people, and it's a very complicated topic. So I'm going to just sort of gloss over it in a way which hopefully is helpful, but doesn't get too far into the weeds. The Copyright Act in Canada contains what's referred to as a reversionary interest in Canadian copyright. So 25 years after an author dies, all of the agreements that the author entered into with respect to their copyright become void, and the copyright reverts back to the author's heirs. Right? So any transfer or sale or exclusive license of copyright ceases to be operative 25 years after the author dies, and those rights revert back to the author's heirs. This is a provision which originated in England. It was intended to protect the heirs of authors. So authors who, the idea was authors create, and I apologize, I should have made this clear earlier. When I say the word author, that is a term of art under the Copyright Act. It just means creators, right? It doesn't mean authors in the sense of people who write things. An author is a creator of any kind of work, right? Visual art, sculpture, software, novels, films, poems, whatever. So the idea was authors, creators suffer from an imbalance of bargaining power, right? They're entering into contracts with publishers, all kinds of people who are going to exploit their work. The authors generally are the weaker party in those negotiations. And so we want to protect authors' heirs from the bad contracts that they've entered into with respect to their work. And so automatically 25 years after an author dies, after a creator dies, their copyrights revert back to their heirs. To figure out who their heirs are, we have to look at their will, essentially. Or if they didn't have a will, we look at the laws of intestacy. This is an automatic reversion. right? So it's not subject to notice. You don't have to send a form to anybody. You don't provide notice to anybody. You don't tell anybody about it. It just happens. Now, the challenge is there's a lot of unanswered questions about how this works in practice, right? Not a lot of people know about the reversion, and it doesn't come up often because there, frankly, are relatively few situations where a library or a body of work will still have significant value 25 years after an author has died. So if you're interested in knowing more about this, you should, come talk to a lawyer who has some experience with it. But I think it's helpful to know that it's out there. I did want to flag the reversionary right, does not apply when an author created their work in the course of employment, right? So we're talking about independently created materials. If it was created in the course of employment, this reversionary right simply doesn't apply. It also doesn't apply to licenses to use materials as part of a collective work. So if you, for example, created materials, articles, let's say, that were going to be included in a magazine or a periodical or a newspaper, that license to use the material in that periodical would not be affected by this reversionary right. I'm just going to answer some of the questions which have come up. If copyright is registered in Canada, is it necessary to register in the US or elsewhere as well? Yes. Because copyright operates nationally, each national registry operates on its own. So if you register in Canada, you still have to register in the US or Germany or the UK or anywhere else. If the novel is available all around the world on the internet, do I have to register the rights in every country in the world? You certainly could. I don't think that there's much benefit to doing that, though. Let me... Copyright also, or sorry, the reversionary right doesn't apply outside of Canada. So I need to stress that again. It only applies to copyright in Canada. It also does not apply to sound recordings, performances, or broadcast signals. I often get asked, is there any way around the reversion? The answer is not by contract, no. The only real way around the reversion is to put something in the will, right? If you put something in an author's will, the reversionary right does not apply to that. But in terms of contracts, you can't contract around this, right? And so you'll sometimes see contracts that have these very Baroque provisions about how the reversionary right doesn't apply, or if there is a reversion, then those rights are automatically re-granted, and none of that works. The courts have been very clear that you can't, publishers and other intermediaries can't get around this by coming up with clever contractual provisions. So 25 years after a creator dies, their rights revert back to their state. So bear in mind that under our current or soon to be current copyright term of life plus 70 years, the heirs are going to enjoy those reversionary rights for 45 years. So make sure that you know about this right. Make sure that you have properly cataloged what you have created, where they have been licensed or sold. Make sure that your heirs know about this so that when the reversionary right does apply, they can take advantage of it. The question was, do reversionary rights apply to audiobooks? It wouldn't apply to the sound recording. No, it would apply to the written text, but not to the sound recording. Okay, enforcing your rights. Very, very high level. As I'm sure you all know, enforcing your rights in a digital environment is very difficult to do, right? It is very expensive to hire a lawyer and go to court. There are very few situations where the value of the remedy that you will get from the court is going to outweigh the value or the money that you pay to your lawyer and the time that it takes. So one thing I always want to flag for creators is don't forget about small claims court. In Canada, you can sue in small claims court for copyright infringement. It's a viable venue for enforcing your rights. You don't need a lawyer, right? And oddly enough, in Quebec, people, artists, copyright owners routinely make use of the small claims court. For some reason, that hasn't sort of trickled out to the rest of Canada as much, but keep in mind that small claims court is always available to you. One question is CPO linked to access copyright or copyback or COVID-Day? No. CPO is run by the government. All of those collectives are private entities. If you're enforcing your rights, you have a series of potential remedies available to you. You can sue for money damages. You can sue for punitive damages. You can sue for statutory damages, which we'll talk about in a moment. And you can sue for the profits that the infringer made. You can sue for an injunction, so the court stopping somebody, preventing somebody, ordering somebody not to engage in the infringing activity anymore. You can even sue for what's referred to as delivery up, meaning if somebody has made a whole bunch of copies, infringing copies of your work, you can seize those copies. You can have them delivered to you, and then you become the owner of them. In terms of how courts handle copyright infringement and calculating the damages, oftentimes they use a fairly common sense approach, and they just sort of say, well, how much did you lose in terms of licensing revenue? How much did you lose in terms of sales royalties? How much did you lose in terms of other money that you could have had but for the infringement? And they'll also award damages for more intangible losses, sometimes related to those moral rights that we talked about earlier, including the effect on your reputation or the lost opportunities for additional professional recognition. Here's how statutory damages work in Canada. So in Canada, a plaintiff can elect statutory damages instead of compensatory damages or an accounting of profits, right? So you say, I'm not going to sue for the money that this person made. I'm not going to sue for my lost licensing revenue. I'm going to sue for what are referred to as statutory damages, which is a fixed range of money set out in the Copyright Act. The way that statutory damages work in Canada is that it's bifurcated. There's two different sort of routes or tiers of statutory damages. There's commercial infringement and there's non-commercial infringement. If somebody is engaging in commercial infringement, the statutory damages range goes from $500 to $20,000 for each work infringed. Now, keep in mind what that means. That means if, let's say you have one song that you wrote and somebody infringes your copyright in that one song, that means you are capped at a maximum of $20,000 for that one song, even if their infringement resulted in 2 million downloads, right? So it's per work. And the court decides where in that range from $500 to $20,000 they want to set the tariff, set the fee, set the penalty. And they take into account all kinds of different things like, how expansive the infringement was, the motivations of the individual, whether they were doing it flagrantly or maliciously, etc. Non-commercial purposes, if somebody is infringing your copyright for non-commercial purposes, like they're not doing it in the context of a business, they're not running a sort of underground commercial black market venture, then the range is much smaller. It's $100 up to $5,000, maximum of $5,000 for all works and all infringements that took place prior to you filing your lawsuit. So sometimes people will think that statutory damages is a great sort of tool. It can be, but you just have to be aware of what the limitations are. There was a question that was raised about website enforcement mechanisms. Yes. So some websites So something like YouTube, let's say, or Facebook will have, or eBay even, they will have an enforcement mechanism built into the website. All right. So for YouTube in the United States, they will have what's referred to as a notice and takedown mechanism. So you can complain essentially to YouTube, right? You don't involve the courts. You just complain to YouTube that somebody is infringing your copyright. And there is an enforcement mechanism which operates under the auspices of the website in question. These can be effective. They can certainly be a lot quicker and a lot cheaper than going to court. And so if you've identified where your rights are being infringed, it then behooves you or your lawyer or whoever is working on your behalf to investigate what the enforcement mechanisms are at the site where your rights are being infringed. Are statutory damages limited if the author uses small claims court? No. You can claim statutory damages in small claims court. I want to flag something here. I just referred, and sorry, actually, before I go on to notice and notice, somebody had asked the question about US approaches to statutory damages. I can't speak with a ton of authority. Here's what I do know about the US approach to statutory damages. It's a much higher range. So I believe the maximum statutory damages under US law is $150,000 as opposed to $20,000. You have to be registered in the United States in order to access statutory damages in the United States. So it is, at least on its face, a more aggressive and rights holder friendly regime in the United States when it comes to statutory damages. Keep in mind that it applies just to infringement that has taken place in the United States. Let's talk briefly about that. I referred a moment ago to the notice and takedown regime in the United States. So if you are in the United States and you find out somebody is infringing your rights on, let's say, YouTube, you can contact YouTube and it triggers what's referred to as a notice and takedown process, meaning that YouTube will take down the infringing copyright. If you're in the United States and I don't know, you get your internet access through, let's say, Verizon or something, and you find out that there's a website operated or made accessible by Verizon, you can get Verizon to take down the content or disable access to the content. That is not the case in Canada. In Canada, we have what is referred to as a notice and notice regime. So if you find out that there's a website in Canada that you can access through Rogers that is infringing your copyright, the only thing that you can do vis-a-vis Rogers is send them a notice of infringement. Their only obligation at that point is to take that notice, pass it along to the operator of the website, and then they're done. Rogers has no more obligations to you. So if you end up doing that, what you then have to do is figure out through Rogers who operates the website, and then you have to go directly after the operator of the website. So this can be a very frustrating process for rights owners. There are some incentives built into the act. If Rogers, let's say, doesn't pass along the notice, they can be liable for damages of $5,000 to $10,000. But this doesn't actually result in your content being taken down, right? It doesn't result in the content or access to the content being disabled by Rogers. All that it is you give Rogers a notice of infringement, Rogers turns around and gives it to the folks who are operating the website, and then onus is on you at that point to pursue further remedies by means of some kind of court action. I'm going to move on to everybody's favorite topic, which is fair dealing. I will do my best to give fair dealing a fulsome treatment in the course of about 15 minutes. Here are some things I want you to keep in mind. Fair dealing is different than fair use. Fair use is a US concept. Fair dealing is a Canadian concept. So I don't want to be so bold as to say anything you have heard about fair use simply doesn't apply to fair dealing, but that's pretty close to being the case. So if you have read materials originating in the United States about how fair dealing or fair use works, for the most part, you're going to have to heavily discount anything that you learn in those materials. Fair dealing is a defense to copyright infringement. It is not a defense to trademark infringement. It is not a defense to moral rights infringement. As a practical matter, I always advise my clients, fair dealing should be your last line of defense. If you want to use something in the course of creating something, maybe it's a film and television show, maybe it's a song, maybe you want to sample another composition or a recording, fair dealing should be the last thing that you rely on, right? Because it's very complicated, it's very unpredictable, it's very ambiguous. We don't have a lot of guidance. And if you get sued, the burden is on you as the defendant to prove that you are entitled to a fair dealing defense. This is a little formula that I like to provide to my students when I teach copyright law. Under fair dealing, you have to have all three of these factors. You have to have an allowable purpose. You have to satisfy any applicable statutory criteria, and your dealing has to be fair. And if you can check all three of those boxes, then you have a successful fair dealing defense and there's no infringement. First step, are you doing it for an allowable purpose? There are 8 allowable purposes, which we will talk about in a moment. Some of those 8, 3 of those 8 allowable purposes have a statutory requirement of attribution, which says if you are doing fair dealing for criticism, review, or news reporting, you have to make attribution to the author or the source of the material that you are using. And then finally, the really ambiguous and the really unpredictable element of this is, are you doing it fairly? And we're going to talk about what that means and how the courts think about fairness. But basically, there are 6 different factors that the courts take into account. If you're thinking about fair dealing, what you have to do is, and we'll see this is how the courts do it. This is how they think about fair dealing. They basically create this sort of matrix. And they check where on the matrix each factor lands, and then they add them up and they go, was the dealing less fair or was it more fair? If it was less fair, then it's not fair dealing. The defense fails and you're liable for copyright infringement. If you get more fair check marks, then the defense is successful and you're not liable for copyright infringement. We're going to go through a couple of cases and lay this out for you exactly how the courts have done this. And this will hopefully be fairly clear as to how they approach this and think about it. One thing to flag here is fair dealing has been characterized as the Supreme Court of Canada. It's not just a defense to copyright infringement, it's a user's right. Right, so that's how the courts often will think about and frame fair dealing. It's not just a defense, it's a user's right. And so in applying fair dealing, the courts have said we don't interpret it restrictively, but it still can be quite challenging to qualify for fair dealing. As I mentioned before, just be very aware, I will double underscore, highlight this. Fair use in the United States and fair dealing in Canada are simply not the same. Probably the biggest difference between the two is in the United States, they have lots and lots and lots of fair use cases. And that's how lawyers think and analyze things. They look at cases. So there are hundreds or thousands of fair use cases in the United States. In Canada, we have maybe 24 fair dealing cases. So it's a much smaller pool. It's much harder to predict how fair dealing is going to play out in Canada in any given set of circumstances. So back to our formula here, allowable purpose plus satisfying those statutory criteria plus fairness equals no infringement. What do we mean by allowable purposes? Right, it's our first step in our little equation here. There's 8 allowable purposes: research, private study, education, parody, satire, criticism, review, and news reporting. And that's it. To qualify for fair dealing, you have to slot yourself into you have to slot what you are doing into one of those 8 allowable purposes. If you can't claim fair dealing as a defense. Now, what the courts have said is we are going to give these words a large and liberal interpretation. So, for example, research has been held by the courts to cover things like people listening to 30-second online previews of songs before buying them, right? The court characterizes that as doing research to decide whether you wanted to buy the song. Private study has also been interpreted to include things like teachers photocopying materials to give them to their students for reading in class. Right? So these definitions, these terms have been given a fairly broad interpretation and application by the courts. Documentary films, for example, have been held to qualify as criticism, review, and potentially news reporting. So usually this isn't where the challenge happens. Right? Usually people can, or oftentimes people can slot themselves into one of these 8 enumerated purposes. It's the fairness test, which is where the challenges really come up. The attribution requirement, the second step, I'm just going to touch on this really quickly. The Act says if you're doing fair dealing for the purposes of criticism, review, or news reporting, then you have to mention the source, so where you got the material. And if it's in the source, you have to give the name of the author, the performer, the maker, or the broadcaster, right? So whether you do that on screen or in the end credits or, at the back of the book or in a footnote or in the liner notes, if you're going to rely on fair dealing for criticism, review, or news reporting, you have to comply with this attribution requirement. Let's talk about the fairness element here, right? The final step in our equation. There are 6 factors that the court says we have to look at. So the motivation, the purpose or the motivation, the character, the amount, the alternatives, the nature of the work, and the effect of the dealing on the work. So as I said before, there's sort of this matrix that we can create here. So down the left-hand side of this matrix, you'll see those 6 factors. Across the top, you'll see whether it's less fair or more fair, and then the kinds of things that slot into each category. Right? So if you have a commercial purpose or motivation, it's generally less fair. If you have a charitable or educational purpose or motivation, it's generally more fair. When we're thinking about character, if you have multiple copies that have been widely circulated, it's generally less fair. If you have a single copy of a work that's only been given to like 3 people, it's generally more fair, and on through that matrix there. You guys have the slides, so I'm going to skip over sort of a deeper dive into each of the 6 factors in favor of spending some time with some actual cases to give you a sense of how the courts look at this. So back again to our matrix. What the courts literally do is they sort of fill in these boxes. They put, essentially an X or a check mark. So this, right, there's more ticks on the less fair side. This would be an instance where the use was found not to be fair dealing. Therefore, it's qualified as copyright infringement. Therefore, the person was liable. Here's how it would look if the courts had decided a different way, that there were more fair ticks. Therefore, it was allowed as fair dealing, therefore not liable for copyright infringement. So let's talk about a couple of cases to give you an example of how the courts have actually looked at this. It's a case decided a couple of years ago, the Wiseau Studios and Harper case. The defendants made a documentary film about the plaintiff and his movie. They used 7 minutes from the plaintiff's movie in the documentary film. Ultimately, the court concluded that this qualified as fair dealing. And you can see here, on all 6 factors, they ended up in the more fair category, right? It was a documentary film. It was for a commercial purpose. Yes, they were looking to make money, but it had a legitimate critical function to it. They were assessing a famously bad movie and a cultural phenomenon that had grown up around it. When they used the clips, they didn't just show the clips on screen, they talked about the clips. They talked about the quality of the movie making. They talked about the techniques that were used in the clips. They talked about how the clips were contextually to be understood and situated. They took 7 of 99 minutes, right? They took 7 minutes from the original film. It was less than 7% or roughly 7% of the movie. And so it was fair on the note in sort of on the idea that the less you take, the more fair it is. If they had taken 60 of 99 minutes, they almost certainly would have failed this step of the test. There was no alternative for them, right? If they wanted to make a documentary about this movie, they basically had to take clips from the movie. He was never going to, the owner of the movie, the plaintiff, was never going to give them a license to do it. The movie, the original film, was publicly available. Anybody could watch the movie. And this documentary didn't negatively affect the market for the original film, right? Nobody was going to watch this documentary in substitute to watching the movie. So it didn't lessen the market value of the movie. If anything, the court held it increased it. So they got all 6 categories. The defense was successful, constituted fair dealing. They weren't liable for copyright infringement. Conservative Party of Canada was sued by the CBC over an election ad. Here, again, held to be fair dealing. Of the 6 categories, 4 fell in favor of the Conservatives. 1 fell in favor of the CBC. And one of the categories, the alternatives category, the court said essentially it was a neutral finding, right? It didn't favor one side or the other. So you just add up how many green ticks do you have? 4. How many red ticks do you have? 1. 4 in the more fair category, in the more fair column, means it constitutes fair dealing. Let me give you an example, and I'll end here with a case where the fair dealing defense failed. So here, what happened was there was a website which was providing sort of marketing research to its users. They took photos taken by the plaintiff and used them on their website. Here, they lost, the defendants lost, right? Of the 6 categories, 3 were held to be less fair. Only 1 was held to be more fair, and 2 of them were neutral. So again, we just add up the ticks. There's 3 red ticks to 1 green tick. 3 of them are in the less fair category. It's not fair dealing, liable for copyright infringement. And what did that mean? It meant that the defendant was ordered to pay about $4,000 in damages and about $9,500 in legal fees. So with that, I will stop sharing my screen, and I'm happy to take any questions that anybody might have.
Boy, no wonder you have to go to school to study this stuff.
It's exciting stuff, let me tell you.
Yeah, I can imagine. I have a couple of questions based on what what you've been telling us. One of them is about moral rights.
Yeah.
Since it sounds from what you were saying like a creator has to suspend the moral rights in most cases, what's the benefit of having them?
That's that is a very astute question. So
Thank you.
let me sketch something out for you. So as I said, copyright is different in different countries, right? Canada sort of falls in this weird kind of midpoint between how countries treat moral rights. So in the United States, they essentially have no moral rights. They do have moral rights, but for a very small sliver of work. And that sort of aligns with our kind of stereotypical view of the US, like, and their creative industries, like kind of out to maximize profit. They don't really care about all of this fluffy stuff about moral, creators having dignity and whatever else. Countries like France and Germany have very, very robust moral rights regimes, meaning there that authors can't waive their moral rights, even if they wanted to. Canada's in the middle. We have moral rights, but you can waive them. So there are people who say, well, this is kind of a fake moral rights regime, right? Because if you can waive them, and if we recognize that authors and creators generally are the ones with less bargaining power, the reality is they're almost always going to be waived. So you've sort of taken away with one hand what you purported to give with the other hand. So yeah, that it's not great. I wish it was different.
Yeah. A couple of questions in the Q&A box as well, Bob.
Yeah.
I copyrighted my audiobook in Canada before its release, but not in the US. Can I obtain a US copyright now and still be fully protected there?
Yes.
Oh, that was easy.
Yeah, no, it's pretty simple. The only time where it gets sticky in the US is if you basically if you register it after you've started a lawsuit, or if you register it knowing that you're about to start a lawsuit, then the courts will kind of say, well, like you only really registered this in order to sort of avail yourself of the lawsuit. But yeah, there's no sort of timing requirement in terms of, if you registered it in Canada in 2020, like you have to register it within a year or whatever. In the US, you can register it whenever you want. So certainly if it's something that you think you want to do, I would recommend that you do.
Is the reverse true? Now, this is actually a question for me personally, because I released a song 4 years ago, and based on what I had read, I registered it with the U.S. Library of Congress to make sure the American copyright was there, but I didn't register it in Canada. Is it
Not a
too late
problem.
to register it here?
Not at all. No, you can. The registration processes are essentially completely independent of each other. Okay. So you're totally free to register it now in Canada.
Great, because I've almost made enough money to cover what it costs you to register the tune in the States, and so I'll have to go into the hole to register it in Canada as well.
There you go.
Another question we had: what is fixation?
Okay, so fixate, it's a good question. So the way that copyright works in Canada and in most countries around the world is that we say that something needs to be fixed in order for it to be protected by copyright. Essentially, what is meant by that is that the work in question has been embodied or recorded or somehow made material in some way, some relatively permanent way. So if I write a book, the book is written down, I can point at the book and say, that's the book. If I write a song, I can either record the song, right, and fix it in that way, or I can write down the notation of the song and fix it in that way. If I paint a painting, as soon as I paint it, that means it's fixed. So what are some examples of things that maybe are not fixed in that way and therefore wouldn't be protected by copyright? So some examples might be sand castles, right? If you build a sand castle on the beach, it's going to get destroyed by the tide pretty soon. Probably not fixed. A garden, right? Gardens are not fixed. They're constantly growing or dying if it's my garden. So the garden isn't fixed in the way that we would think of as being required by copyright law. Even if the garden is really beautiful, right? Like even if it's very methodically and purposefully set out and laid out and designed so that it blooms at certain colors bloom at certain times and certain things happen at other times, that is probably not fixed. Sort of a classic example of something that is not fixed is a verbal off the cuff speech, right? Like if I'm on King Street, if I go down onto King Street and I just start yelling at people on the street, no matter how thoughtful my words are, no matter how insightful whatever I say is, unless I write it down or I record it, it's not fixed, right? It hasn't been made permanent in some way. And so I don't have any copyright in whatever it is I yell while I'm down there.
Okay, we're suddenly getting a bunch of questions. As a fine artist, what are my limitations of what I can paint of old photos or newspaper articles, but proof of ownership is impossible?
So, that's a question that unfortunately you're probably best positioned to speak to a copyright lawyer about that, because the answer is going to depend on a bunch of different factors, including what it is that you want to paint. The things that you want to paint may be in the public domain, and there may not be any restrictions on your ability to make use of them. On the other hand, they might still be protected by copyright, and therefore you would face, a potential claim for infringement if you use them in your work. So, unfortunately, it's difficult, if not impossible, to answer in the abstract. But yeah, you may want to speak to a lawyer or contact something like the Artists Legal Advice Service, which is run out of Osgoode Hall or U of T, and they can give you some pro bono advice on how that would work.
Another question: if I license my artwork and haven't registered it, and it's available for licensing to the entire world, is there any point registering copyright that all my creativity is? Oh, that went away suddenly. So maybe the person.
So yeah, no, it's a fair question. I mean, is there any purpose to registering the copyright? There are certain advantages. It's really a cost benefit analysis, right? For $50, are you going to get any advantages? You are going to get certain advantages if you ever end up in litigation over that artwork. For some people, that $50 is just not money well spent, right? They have better things that they can spend their money on. They don't think they're ever going to end up in a lawsuit. And so it's just not sort of something that they should be doing. For other people, if they have the budget for it, there are advantages, if the worst comes to worst and you do end up in a lawsuit over it. So, to me, I would say, look, if you have the budget for it, register it. If it's something that is going to be a burden and like I said, you have better things to spend $50 on, spend the $50 on those other
things. Here's a question: as a Canuck, creating works in the U.S. legally via American immigration requirements of a work visa granted by the U.S., do I claim that all my creativity is Canadian?
So I guess the answer to that is you don't need to claim that your creativity is any particular nationality. Copyright arises in each country, regardless of where it was created. So there is a sort of web of international treaties that are in place. And so if you are a Canadian who has created something in Canada, or if you are a German who has created something in Canada, or you're a Brazilian who's created something in Canada, you are protected by Canadian copyright, regardless of your citizenship or your place of residence. And the same is true in all of those other countries, right? Canadians can go to Brazil and sue for copyright infringement. Brazilians can go to Germany and sue for copyright infringement. Germans can go to the US and to Canada and sue for copyright infringement. So we don't need to sort of give artwork or creativity kind of a brand or a national identity.
Okay. If you put an original song on Spotify or YouTube, do those platforms or others typically own any copyright or any rights at all?
Typically, no, they would not own copyright. So, and certainly if you're dealing with sort of a reputable, or one of those kind of, iconic websites, they will not own any, they will not take any copyright in anything that you put up on them. Depending on the website that you're using, you do have to be careful because they may have something weird in their terms of use, which would purport to give them ownership. But for the most part, and specifically for Spotify and YouTube, no, they are not taking ownership of anything.
Okay. Here's an interesting question. I've written over 200 songs and writing more. Good on you. Registering individual songs would be expensive.
Yeah.
He says he's finally getting around to recording most of these songs and putting them out there. Assuming 30 or so are good, what's the best method of registering copyright? I guess, is there a bulk deal?
Yeah, unfortunately, there isn't a bulk deal. Oftentimes, what our clients will do is they will register things that are making money, essentially, right? So you don't have to wait until they're making money to register them, but there's no harm in waiting until they're making money, right? Like you don't lose anything by waiting until it's made money. And so what they will do, particularly when it comes to songs, is they will register, if they have a catalog of songs, they will register, let's say, the top 10% of the songs in the catalog, because those are the ones that are more likely to end up in litigation. And registration really, as I mentioned before, it really helps you if there's a threat of litigation or if there is litigation. So you can wait until you've figured out which ones make money and then you register those.
Okay. If you want to create a film based on a play that's in the public domain, but it was in another language, and if you use a translation of the work, are you infringing on copyright with that translation? So do you have to get a new translation?
So this is starting to sound like one of the questions that I pose to my students in my copyright law courses. So it's a good question. The answer is essentially, it's based on what you've described. Yes, it sounds like the translation itself will be protected by copyright. So each translation is a separate copyright protected work. So, like, for example, if I have a William Shakespeare play, clearly in the public domain in English, because it was written 500 years ago. But if somebody today translates that play into French or into German or into Chinese, each of those translations will have a separate copyright. So you have to be very careful with translations. You have to, identify when the translation was made and who made it and whether that person is still alive or has died within the preceding, 50 or 70 years. So the translation itself could still be protected by copyright. So yeah, you may need to obtain your own separate translation of the work.
Okay. A question of clarification here. You mentioned something run out of either Osgoode Hall or U of T for artists.
Yeah, let me just bear with me for 1 second. It is, I'm just Googling something for some reason. Yes. Okay. So there is a pro bono service called Artists Legal Advice Services. What I'm going to do is I'm going to put that into the chat. I think I can put something in the chat here.
Should be able to.
How do I do that? Hold on, I'm going to close the Q&A. Oh, here we go. And boop. Okay, so there's a link that I just put in the chat to what's often referred to as ALAS. It is a pro bono service run by lawyers and law students in Ontario, and you can call them and schedule a meeting.
Okay, great. if a person creates a storyboard for a film and is under contract that says the film owns the work, does the artist own anything?
Not if they've signed a contract like that. No.
And we've got a couple of questions about visual artists, but it's more information. So let me see if I can sum it up here. If you're not registered, oh no, that's another question. Let me ask this other question first.
Okay.
If you're not registered at all, I guess,
Mhm.
can you still claim for infringement?
Yes.
It
In
is
Canada, you
practical to
can.
register everything, especially
Yeah.
everything a visual artist does.
100%. Yeah. In Canada, you do not need to be registered to file a claim for copyright infringement. It's helpful if you have the registration, but it's not required.
Of course. And kind of another response to that is by somebody who mentions Imprimo for visual artists,
Mm.
which will register works for a small monthly fee.
Yeah.
And that's run by our friends at Carfac. So that's
Mhm.
something definitely worth looking into.
Yeah.
And RAV in Quebec does the same thing, RAAV.
Mhm.
Oh, no, that's legal advice to visual artists. I think that's pretty much it, Bob. Thank you
Okay.
so much.
Thank you. I appreciate you all being so patient and listening to me
Are you kidding?
ramble
This is
on about copyright.
that's why we were here, Bob,
Fantastic.
to hear you do that. So thank you so much
Thank
for
you. I
this.
really appreciate the opportunity.
It was great to have you with us. Bob Tarantino, ladies and gentlemen.
That's all right.
Bob mentioned the sides. I should mention that we will be sending out Bob's slide decks, so you can expect to receive that. And we did record this, so we will be posting the recording as soon as I can get around to it, hopefully within a week or so. So that's, I think, about it. Thank you so much for joining us today. We've got more webinars coming up in the months to come. Social media from beginner to expert. What to do with your stuff, legacy planning. We're going to be working with Carfac on that coming up probably in November. And if you think you might enjoy an online conversation with your peers across the country, please consider our online salons, They're discussions and networking sessions. They take place every 3 weeks or so. We've got one coming up 2 weeks from today, and you can register on our website at CSARN.ca. So that's it for us today. Thank you so much for joining us. Take care, be well, have a creative day, and we will talk again.